currently work remotely,
Okay.
but the majority of the team is working in office.
Okay.
Did you guys get kicked off?
You got kicked
No, I
off.
believe you got
Okay. I
kicked
just
off.
want to make sure that you guys didn't get kicked off because
Okay.
I don't want the webinar to shut down. And I'm on Wi-Fi in a huddle room, which was really weird that it did that. So I'm actually gonna go back to my desk and throw my earplugs on
Okay.
where I'm
Okay.
hardwired into the system. So
Hey, that's why we join early.
Yep.
yep, exactly.
Not a problem, Robert. But yeah, the majority of the team is in Phoenix, in our
Okay.
office downtown. And so it's not as cold other places and dark, but it's still, once you get used to it, it feels like the seasons change.
Yeah.
Now, Christine, I'm sure you're a pro at Zoom webinar. So you will have access to the Q&A and chat. If you run over time or we can't get to someone, we do have their emails to do a follow-up.
Okay, sounds good. And how do we want
This session.
Okay. So yeah, what I'll do is do the presentation so we can get out all that and get that information, and then we'll have a period of time for questions at the end. So I'll just invite you back on at that time, Robert, and we can flow from
Excellent.
there. I'm just going to take a quick sip of water, and I'll be right back.
Not a problem.
All right, I have internet now.
Okay,
So
good.
I guess that's why Terry was looking earlier to see if we were hardwired or not. So maybe they're having internet issues
Oh
in the
no,
office.
that's the last thing
So,
everybody needs.
all right, well, I'm gonna
Um,
go. Yeah,
Christina was asking when you did freeze if if you wanted her to reach out to Patent for additional follow-up. So when she joins us back, she just went to go get a drink.
yeah, well, definitely we can do that and schedule something for next year for doing
Mhm.
on patents.
Yeah. But that's what it was like. That's when we realized you were frozen because we were like, hello, Robert. But it doesn't sound too loud behind you. Are you at your desk or you
On
got
my
into a
desk,
huddle? Okay.
Albert and Lori are being quiet right now. So
Right now.
Lori said right now.
I heard her.
She heard you, Lori.
And so I shared with Christina about our Q&A. So I told her that you would join at the end of the session. That's when she's going to address those questions at the end.
Okay.
So, and I believe that catches you up.
Thinking of skipping some of the slides too.
Yeah, that's what I just hid some of them, but not all. I kept the majority in that we typically do.
Yeah, I think I'm gonna. Just go with what we have in it. Yeah, Christina, as I caught a little bit and then I cut off, and Faith was telling me with the patent piece, yeah, you could connect again with that
Okay.
team, and then we can try to schedule something for you know sometime next year to do a lunch and learn again there.
Okay.
Um,
So I
that'd be
can,
great.
yeah, I'll definitely send an email out to Ken again, so that y'all can get that scheduled.
All right, well, we're just a few minutes out from going live. So if you need anything, Christina, you can find me in the chat.
Okay.
Otherwise, like I shared, Robert will facilitate the intro and Q&A at the end of the session.
Okay. Sounds good.
It was so nice to meet you, and thanks again for
You as
joining
well.
us.
All right, so my screen should be shared.
Yep, it's up.
I'm just going to go off until it's my time.
Sounds good. I'll start here and I'll go live in about another minute. Got a couple people in the waiting room.
Answers. Just for answering them all.
All right, we are going live.
Unless you like crystals.
Good afternoon, everybody. Thank you for joining us for today's Lunch and Learn. We will get started here in just a couple moments. We're going to let everybody load up into the Zoom app and then we'll jump right into it. All right, good afternoon, everybody. We'll get started here in one moment. Again, we are letting everybody load in the Zoom app, and we will get started here in about another minute or so. All righty. Good afternoon, everybody. Thank you for joining us today for today's Lunch and Learn. I'm Robert Theobald, Small Business Ombudsman and Vice President of Small Business Services at the Arizona Commerce Authority, and we are glad to have you with us today. One of the things we like to do when we start our webinars and our Lunch and Learns and workshops is see where everybody is tuning in from. So if you could post in the chat where you are from, we'd like to see from where throughout the state, sometimes outside of the state, we have our participants joining from. So again, post that up in the chat. We got Wickenburg, Scottsdale, North Phoenix, Chandler, Boston. All right, guess we from Boston. Thank you, Mike. Casa Grande, Sedona, Glendale, Phoenix, but in Tucson today. All right, thank you, Matthew, for tuning in from Tucson. Excellent. We're glad to have everybody with us today. If you're new to the Small Business Bootcamp 1, we'd like to thank all of our community partners. We have a lot of partners that help us with the Lunch and Learns, with the weekly webinars and other stuff. And we cannot do these without their time, their effort, and their expertise. Also, for those that are new, this Lunch and Learn is part of our Small Business Bootcamp programming. The Small Business Bootcamp consists of a weekly webinar every Tuesday morning. And then we do some workshops, Lunch and Learns, and other stuff. And the great thing, they're designed to help small businesses prepare, plan, and grow. But all of our virtual ones, we are able to record. So today's session will be recorded, and we post those recordings in our content library. And our content library has a very wide collection of over 350 recorded webinars and workshops that you can access at any time. You can watch the recording. You can access the slide decks that the presenters used to help you get that information from those sessions. So it's a great resource, and Faith will post in the chat links directly to that. You can find it at the bottom of the Small Business Bootcamp webpage where you went to register for today's session. Another thing, the ACA has a number of different programs to help support small business. You can find those at azcommerce.com/programs. But I do want to talk about one as it ties into today's Lunch and Learn, is our small business checklist. This is an online interactive tool on our website that helps small business owners identify the commonly requested licensing, registration, and compliance requirements at the local, state, and federal levels. It also includes information and links for, such as today, we're talking about trademarks. There's links for the U.S. Patent and Trademark Office, for the Secretary of State's office, and other things to help you protect your business and learn about the other pieces of growing and running your business. So it is an amazing resource. If you scan that QR code, it'll take you to the webpage. And we also have a virtual assistant on there, Sally, that can help you out, or you can dive right into the very in-depth information on the checklist. A quick look at our upcoming webinars. These are our Tuesday morning webinars. We've got some great sessions coming up. And with that, we're going to move quickly into today's session. We're excited to have Christina Calloway from the U.S. Patent and Trademark Office. I actually met Christina at a workshop we did together up on the Navajo Nation for an event they had going on. It was a great event, and I've seen this presentation before and knew we had to bring it to all of our Arizona businesses and our Boston business that's on with us today as well. So with this, I'm going to stop sharing my screen, and we're going to turn over to Christina and let her take control. As she's setting up, if you have questions, please place those in the Q&A at the bottom of your screen. We will jump into questions at the end of the presentation and try to answer those for you. And we may have some interaction in the chat as well. But again, questions, please post those in the Q&A. And Christina, it is all yours.
Great. Thank you so much, Robert, and thank you for having me this afternoon to discuss trademark basics, what every small business should know now and not later. Again, I'm Christina Calloway, an attorney advisor in our Trademarks Customer Outreach Office at the USPTO, the federal agency that is responsible for granting patents and registering trademarks. We'll be talking all about registering trademarks today. So I'm going to quickly go over our agenda and then we'll get into the meat of today's presentation. Again, like Robert said, if you have any questions, just drop those in the Q&A. We'll have the time at the end to address those questions live. I'll invite Robert back on so that we can go over any questions that you have regarding today's presentation. All right, so we're going to be talking about our trademark fundamentals, some definitions, what is actually is a trademark, intellectual property. We're going to talk about the benefits of federal registration with the USPTO. Then we'll go over selecting a trademark, what that means if you already have a trademark or if you want to make your trademark more distinctive or you're creating one. We'll talk about that a little bit. We'll briefly go over the filing and registration process with the USPTO, and then I'll be providing some resources and materials that the USPTO has to assist you with the federal registration process. So without further ado, let's get into those trademark fundamentals. So first, I'd just like to start with that trademarks are a type of intellectual property, okay? So intellectual property is something that you are creating with your mind. It's not real tangible property, not like a house or real estate, those types of things, but a type of intangible property that can still be bought, sold, traded, inherited, licensed. So still very important for you as a small business owner. What is a trademark? A trademark is a type of intellectual property that's going to be indicating the source of your goods and/or services. So anything you're using to indicate the source of goods and services could be words, terms, phrases, numbers, an acronym, could be design elements, color, or any combination thereof, whatever you're using to indicate the source of your goods and services. So I'm showing here on the screen some very well-known types of trademarks, and I want you to think about as we're going through some of these, what you connect what indicates the source of these particular goods and services, what you connect these marks to. So when you see that half-bitten apple, that Apple logo, you're probably immediately thinking of their smartphones or computers or maybe their music streaming services, right? When you see Coca-Cola and that famous script, you're probably immediately thinking of those carbonated soft drinks or their carbonated beverages that they provide. When you see that Amazon logo, you're probably immediately thinking of those online retail store services where you can buy and purchase any and everything. Or when you see that Nike swoosh, that's called a swoosh symbol for Nike, you're probably thinking of footwear. Or that Ford logo, you immediately think of motor vehicles, right? So you see how these trademarks are indicating the source of some type of good and/or service. All right, so a trademark identifies the source of goods and services. It also helps you distinguish your goods and services from those of a third party. So let's use an example here. Think about Coca-Cola and Pepsi. You might hear me talk about Coca-Cola a lot here. I'm originally from Georgia, so I'm a Coca-Cola girl. So with Coca-Cola and Pepsi, they're providing the same types of goods, right? But you probably prefer one over the other. You might prefer Coca-Cola over Pepsi, Pepsi over Coca-Cola. So when I walk into a store and I ask for a Coca-Cola, I do not want them to hand me a Pepsi, right? I'm brand loyal to Coca-Cola, even though they're providing the same type of goods, right? A carbonated soft drink. Those trademarks, Coca-Cola and Pepsi, help to distinguish those goods, right? Providing economic value. I'm putting money into Coca-Cola's pockets as opposed to Pepsi, helping distinguish Coca-Cola, those brands help distinguish their goods from one another's or their competitors. The same goes for you. A trademark helps you distinguish your goods and services from those of another party's. As well as a trademark provides you with legal protection for your brand, helps you have that brand distinction, that brand identity out in the marketplace, providing you with legal protection for your brand. So now we've talked about what a trademark does for you. It indicates the source of your goods and services, helps distinguish your goods and/or services from those of another party, provides you with legal protections. Let's talk about what it does not do. So a trademark does not give you exclusive rights to words or terms outright. So a lot of times we hear people say, "Oh, I'm just going to register a trademark." Well, now you know it has to be connected to some type of good and or services. You do not have the rights to that term word in your trademark outright. So let's use Apple for example. Apple is a common word, general word, and identifies a type of fruit. But Apple has a registration to use that particular term in connection with their smartphones, their computers, their music streaming services. Does not mean they legally own the word Apple outright. It doesn't mean that they can stop other people from saying the word Apple or that we owe them money every time we say the word Apple. Trademark registration is providing you with an exclusive right to use that word or term in connection with your goods and or services. All right, so throughout the presentation, you'll hear me referring to trademarks for both services and goods or products. But actually, trademarks indicate the source of goods or products, and then a service mark indicates the source of services. It's okay to use the word interchangeably, trademark for both goods and/or services. You'll hear me use it that way. Just want to make that distinction, especially when we're talking about the types of symbols you can use next to your trademark or service mark. All right, so when you have a trademark, you probably don't say the word trademark. You probably don't say, "I have a trademark for my brand," or "This is my trademark." You probably say, "I have a brand name or a logo or slogan that you use in connection with your goods and or services." Those are our common type of source identifiers: brand names, slogans, and logos. So here with Coca-Cola, I'm showing their slogan, "It's the real thing," and then Coca-Cola, just these terms. But we don't normally see their particular registrations in this manner, right? Remember, I said a trademark can be words, terms, phrases, numbers, a combination thereof, or design elements and color, or a combination of all of those types of elements all together. So when we see Coca-Cola, we normally see it in that famous script. We see it with some color, usually in red or white. Might see some design elements in there. Always Coca-Cola, always the real thing, in combination as their logo or their trademark. Also, Coca-Cola has a registration for the shape or configuration of their bottles, right? That famous bottle, if you see it, you know immediately it is a Coca-Cola branded product. And it's so distinctive that it indicates the source of those goods, just the packaging alone. So that's a type of non-traditional type of mark. Takes us right into our non-traditional types of marks. So anything that is functioning as a source identifier might be eligible for registration. We just talked about that Coca-Cola bottle. The configuration or the packaging of those goods is so distinctive that it is a trademark that helps indicate the source of those carbonated soft drinks. Let's talk about some others here. So with sound, think about the NBC chimes, right? If you turn on NBC, you see the broadcasting or before one of their television shows, you'll hear those three chimes, maybe that animation of that stylized peacock. Those three chimes are a registered trademark for their television broadcasting services, right? You hear it, you immediately know that you're on the NBC channel. Think about color, right? If you think about handing someone a robin's egg blue box, they might get very excited even before seeing the label on the top of that box because they know that is a Tiffany's box. The color of that packaging, robin's egg blue, is a registered trademark for Tiffany in their jewelry goods. Scent and smell. Think about Play-Doh. If you have children or even as an adult, you probably remember the distinctive scent of Play-Doh. That a musky vanilla scent is a registered trademark for the toy molding compounds, right? So distinctive that it is indicating the source of those particular goods. With motion, think about that roaring lion before you see a film, that Go and Metro Myers roaring lion for those film production services, right? It's letting us know who is providing the production of this particular film we're watching. Holograms, maybe on baseball cards or on an American Express credit cards, those can indicate the source of those credit card services or those baseball goods. And we already talked about that configuration or shape that can also indicate the source of goods and/or services. So anything that functions as a source identifier might be eligible for registration. It has to be so distinctive that it is indicating who the source of those goods and services are. All right, so we've gotten through our trademark fundamentals. Let's go through a couple of knowledge checks. I like to just see if you've been paying attention to the information that I've been providing. We'll go through these and we'll go on to next, the benefits of federal registration. Feel free to just think about these on your own, or you can drop your responses in the Q&A just so I can see them, see what we have going on out there during the webinar. All right, so our first knowledge check. Does a federally registered trademark mean that you own a word or a phrase? Does a federally registered trademark mean that you own a word or a phrase? All right, great. I see people already answering. The answer here is no, right? It just means that you have exclusive right to use that word or phrase in connection with goods and or services. Our next knowledge check. Do you have to use your business name as a trademark? Think about that one. Do you have to use your business name as your trademark? Right? I'm looking, yep, getting a lot of no's. They're coming in fast, quickly. Right here, it's no. You can use your business name as your trademark, but you don't have to. You could have something totally separate from your business name that you're using as a trademark, and you have your business name, right? Pepsi has the term Pepsi for their carbonated soft drinks. But the actual company name is PepsiCo, right? We don't go and ask for a PepsiCo. They're using a totally different trademark separate from their business name. Or you can use your business name as your trademark. Think about Amazon. That is the business name of Amazon. They also use that as their trademark. You make that determination and decision as the trademark owner of what you want to use to indicate the source of your goods and services. All right, thank you for your participation. Let's talk about those benefits of federal registration. So in the United States, trademark rights are based upon usage. You have to be using your mark in commerce in order to have trademark rights. And there are two traditional ways of creating those rights: common law trademark rights, as well as federal registration with the USPTO. Let's briefly cover both of those. So with common law trademark rights, as soon as you're using a trademark in connection with goods and/or services in commerce, then you have a trademark. You have common law rights in that trademark. When you file an application with the USPTO, you're not purchasing a trademark from us. We're not telling you what your trademark is. You're already telling us what trademark you have in connection with goods and services. So as soon as you're using terms, phrases, a brand name, logo, a slogan in connection with your goods and services in the marketplace, then you have a trademark. Keep in mind that registration with the USPTO is not required. It's voluntary. So you make a determination of whether or not you want to file for federal registration with the USPTO. With common law rights, your trademark rights are limited to the geographic area where you are using the mark. So say, for example, you have a farmer's market and you're selling candles every Saturday at that farmer's market in a city in Arizona, and you are using that trademark. You have something on the label of those candles. You are selling them to people at that farmer's market. You have a trademark that's being used in commerce. You have those common law trademark rights, but it's only going to be limited to Arizona, the state of Arizona. With your trademark, you have the option to use TM for trademark in connection with your goods or products, or SM for service mark in connection with your services. You would not be using the R with a circle, which indicates a federally registered trademark. But even prior to filing for federal registration, you can use TM or SM. This is just indicating that this is a trademark that you're using in connection with your goods and/or services. But say someone purchases your candles, say from, I'm going to pick on Mike here in Boston, say from the state of Massachusetts, they're visiting Arizona, and then they purchase that candle, they take it over to Massachusetts, they say, hey, this is a really great trademark. I think I am going to start using this particular brand name on candles at my local farmer's market in Massachusetts. You would not have any rights there. Your rights only extend to the state of Arizona. You do not have any rights in Massachusetts. So this is one reason why you might want to be filing for federal registration. The rights that you have with federal registration with the USPTO are going to be created when you get that federal registration. it's going to put the public on notice or provide legal presumption that you own that trademark, and your rights are going to extend to all 50 states and the U.S. territories. Okay, so then you would have the right to tell someone in Massachusetts they cannot be using your trademark in connection with candles. Okay, they are infringing upon your trademark. Like I said, it's also going to put the public on notice of your rights in that trademark. Other rights with federal registration are that you can bring a legal action concerning your trademark in federal court. And you do need to have a U.S. registration in order to do so, okay, to file what is called a trademark infringement lawsuit. You can also record your U.S. registration with U.S. Customs and Border Protection. So think about goods that are normally knocked off or copied, okay, like apparel goods, maybe handbags, maybe electronic goods, maybe software goods. Think about those things. And if you file your U.S. registration with U.S. Customs and Border Protection, they can prevent the import of goods that may be infringing upon your trademark, right? Which is important, right? That takes money out of your pocket. And also someone may be selling goods or providing goods that are not of the same standard or quality of your goods and products. Additionally, with your U.S. registration, you would be able to use that as a filing basis in another country. There are no worldwide or international trademark rights. When you get a federal registration with the U.S., that's only going to extend to the 50 U.S. states and then to our U.S. territories. If you say are manufacturing your goods in another country, you would have to file for trademark rights in that particular country. And that may be something you want to consider doing. With your U.S. registration, you'd be able to use that as a filing basis to file in another country. But again, there are no worldwide or international trademark rights. You have to file in each country where you want those trademark rights. Once you receive federal registration, it is unnecessary to use that TM or SM symbol, and you are now permitted, not obligated to, but now are permitted to use that R with a circle symbol to show that this is a federally registered trademark. You can choose not to add this to your trademark. Your trademark or federal registration is still going to be in the USPTO database, so the public would still be on notice that you are the owner of that particular trademark. All right, 2 more quick knowledge checks before we get into how to select a trademark, what we're looking at with the analysis we are looking at with that. Are you required to register your trademark with the USPTO? When you have a trademark that you're using in connection with goods and/or services in the marketplace, are you required to register your trademark with the USPTO? Again, you can just drop your answers there in the Q&A. And the answer here is going to be no. Federal registration is a choice. You're making that decision as the business owner, as that intellectual property owner, whether or not you want to receive those federal benefits of registration. So it's not required. But a lot of trademark owners opt to do that, right? Because you get that broader expansion of your rights across all 50 states and in the U.S. territories. All right, does registering your trademark with the USPTO give you international protection? When you receive that federal registration from the USPTO, does that mean that you're going to have international trademark protection? I'm seeing those answers coming in really fast. Great. The answer there is no. Registering your trademark with the USPTO is only going to provide you with rights in the United States and in our U.S. territories. Keeping in mind, though, if you have that U.S. registration, you can use your U.S. registration as a filing basis in other countries. All right, let's talk about selecting a trademark and the analysis that the USPTO is looking at when we're reviewing your applications. Okay, the mission of the USPTO is to register any trademark that is eligible for registration. You're not purchasing, like I said, a trademark from the USPTO. You're coming to the USPTO telling us what your trademark already is. You are applying and paying fees to seek federal registration, but there is no guarantee that you will receive federal registration. One, because not every trademark is going to be registrable, and not every trademark is going to be enforceable. So when you're thinking about your trademark or the trademark that you may currently have, you want to select a trademark that is going to be both federally registrable and also legally protectable. There are 2 main concepts here, and we're going to discuss both of those. The first and the most common type of refusal that applicants receive is a likelihood of confusion refusal. We're going to talk about both of these in just a moment. And another type of common refusal is a descriptiveness refusal regarding the strength or distinctiveness of your trademark. All right, let's talk about likelihood of confusion. This is the most common type of refusal that applicants receive when they are filing an application with the USPTO. The concept here is that you want to avoid confusing consumers about the source of your goods and services. Remember, your trademark indicates the source of your goods and services. You don't want that to be confused in the marketplace. Why? Remember, we talked about that distinguishing between your goods and services between those of another party. It has economic value, right? It can literally take money out of your business. So we want to avoid confusing consumers in the marketplace. We use a test in order to do that analysis, the same analysis that the examining attorneys are going to be doing when they are reviewing your application is the same analysis that you can use prior to filing your application to make sure that you have a stronger foundation for your application to move forward to registration. The first prong of that test is going to be, are the trademarks confusingly similar? We're going to be looking at, is your mark, does it look alike, sound alike, have the same meaning and connotation or commercial impression as an already registered mark? So we're looking at look alike, sound alike, meaning and connotation, and commercial impression. The second prong of that test is, are the goods and services related? Not just identical, but are they related? Okay, so if you meet both prongs of this test, or the examining attorney is reviewing your application and finds a registered trademark is confusingly similar for same goods or for related goods and or services, you're going to receive a likelihood of confusion refusal. We don't want that to happen. When we're talking about relatedness of goods, just because your goods are classified in the application in a different class or heading of goods and or services does not mean that they are different. They could be related. So think about, you may come in with an application for human clothing apparel that are like shirts and baseball caps or clothing jackets, pants, footwear, dresses, blouses. And then you also, then we find a registered mark that is for tote bags and handbags and purses and wallets in a whole nother class, class 18. Would those be related goods? Are consumers used to seeing one company provide both clothing apparel and also purses, handbags, tote bags, and wallets under the same brand name? More than likely, yes. So that would result in a likelihood of confusion refusal. Now you may be thinking to yourself, okay, if I don't meet both of these prongs, then I don't have an issue, right? So you could have a mark that is confusingly similar. Think about Delta for faucets and Delta for air transportation services, right? Identical marks. They look alike, they sound alike. But are consumers used to going to the same brand for air transportation services and water faucets? Probably not. So those registrations are able to coexist in the USPTO database and out in the marketplace with no confusion. All right, so they're not meeting both prongs of that particular test. Let's do a few examples here of this analysis, and I want you to put on your trademark examining attorney hat here as we go through these examples, the same, like I said, analysis that we use when we're reviewing applications. All right, so your trademark or the trademark application is going to be T-Markey for shirts, and the registered trademark that we find in the USPTO database is T-Markey for pants. Would you allow this application to move forward to registration? And I'll just take a second to see what we have dropped into the chat. Would you allow T-Markey for shirts to move forward to registration, even though we have a registered mark for T-Markey for pants? Right? Getting a lot of the same answers right here. Yes, this would result in a refusal. Let's go through our analysis. Are the marks confusingly similar? Yes, they are identical, right? They look alike, they sound alike. Shirts and pants. Are consumers used to seeing the same company provide shirts and pants under the same mark? Yes, right? I can probably name 5 off the top of my head. Gap, Ralph Lauren, Tommy Hilfiger, Nike, Puma. They're providing shirts and pants all under the same mark. So here, this would result in a likelihood of confusion refusal. All right, let's do another example. We still have our application for T-Markey for shirts. We're changing our mark a little bit here. It's T-Markey for pants. would you allow that application to move forward to registration? Thinking about that analysis, would you allow this application to move forward? Right? Getting those answers in. I'm seeing a lot of no's here, right? So this would also result in a refusal. Let's go through our analysis again. Are these marks confusingly similar? Do they look alike? No, they don't look alike. They're spelled differently, but do they sound alike, right? Think about a radio advertisement, right? If you were saying T Markey and T Markey, I pronounce them in the same way. That means another public consumer may pronounce them in the same way. So they are confusingly similar. And then we know from our last example that shirts and pants, the consumers are used to seeing shirts and pants provided by the same entity, business entity. One more example here. Your trademark is T Markey for shirts, and then the registered trademark is going to be T Markey for golf flags. We're changing our goods a little bit here. Would you allow this application to move forward to registration? Thinking about that analysis, right? I'm getting split here on the answers, which is great. We're thinking about it a little bit more about what we would let go and what we would let go through and what we wouldn't. Same thing that the trademark examining attorney is going to be doing. I can tell you right now, I am not a golfer. I don't know much about the products that you find in a golf pro shop or something of that nature. So we know from our last example that these marks are confusingly similar, right? They sound alike, T Markey and T Markey. But as far as our goods, are these related? Would consumers be used to seeing shirts and golf flags sold under the same mark by the same company? Now, I don't know. I don't know if I walk into a Callaway Golf if I'm going to see polo shirts for golf and then golf flags sold under that Callaway Golf mark. So I might say here, it probably may not be confused. But I'm seeing some answers in the chat that are saying, yes, there could be some confusion there. Maybe they know, or they're golfers, or they've been in a pro shop and they say, yes, there are companies that both provide shirts and also those golf flags. So there could possibly be some confusion there. All right. So when we're a little bit split on that, even as a trademark examining attorney, we're going to do a little marketplace research. We're actually going to go on the internet and see if we can find companies that are providing both of these types of goods under the same mark so that we can make that determination of whether the goods are related. It's the same type of research you can do prior to filing your application. You file an application, you're paying fees. You do not get those fees back. They're non-refundable if your mark does not go through to registration. So you're doing a little homework, what we call a little bit of homework or a clearance search prior to filing your application so you don't run into an issue where you're receiving that likelihood of confusion refusal. What do I mean by clearance search? You would be searching our USPTO database, which consists of federally applied for and registered trademarks in the database. This is available to you at uspto.gov. It's free to search and available 24/7. Okay, it's like a search engine. You'd be able to search that to see if you can find, or if there are any marks that are confusingly similar for related goods and or services to what you may be applying for. You're also going to be looking on the internet in your clearance search, right? Because you're going to also be searching for common law use, right? There are some business owners or trademark owners who say, we are not filing for federal registration, right? We know that is not required. They still may be using the mark in the marketplace, right? They have those geographic rights where they are currently using that mark. So you're still going to want to be searching on the internet for possible common law usage when you do that clearance search. You are not required to hire an attorney to file an application with the USPTO. We do recommend it. And if you do, we recommend that you hire an experienced trademark attorney. You can file an application on your own or pro se with the USPTO. But if you do hire a private trademark attorney, they're also going to be conducting a comprehensive clearance search on your behalf before filing your application. They're also going to look in the USPTO database of registrations and applications. They'll look in state trademark databases. They'll look at business name registries. They'll look at foreign trademark databases, and they'll also be looking on the internet. So they'll be looking in some places you may not be as familiar with, but they'll also be conducting that clearance search prior to filing the application. All right, one more last knowledge check before we move on to the strength of your trademark and that second common refusal that applicants receive. Our trademark is X-seed for agricultural seeds, and then that registered trademark is X-seed for live plants. Think about that likelihood of confusion analysis and whether or not you would allow this application to move forward to registration. Right? Answers are getting a little slower as people are thinking about that analysis, right? Remember, with confusingly similar, we're looking at whether they look alike, sound alike, same meaning and connotation and commercial impression, and then we're looking at whether the goods and services are related. So let's go through that analysis here. Do these marks, are they confusingly similar? Do they look alike? No, not necessarily. They're spelled differently, but they do sound alike, right? I pronounce them in the same way, X-seed and X-seed. And then for our goods, are these related? Agricultural seeds and live plants. Okay, I can probably think about a greenery that I go into or plant shop where they're providing the actual agricultural seeds and then live plants. So here, this would result in a likelihood of confusion refusal. All right, so we got likelihood of confusion down. Let's talk about strength of the trademark. So the concept here is that you want to avoid using trademarks or having a trademark that fails to indicate the source of your goods and services. The test here we're looking at, does your mark merely describe the goods and services? Remember, we want our trademark to indicate the source of the goods and services, not just merely describe what our goods and services are, right? That's not distinctive. A public consumer is not going to look at that and associate your business as the source of those particular goods and services. So we have a temperature gauge graphic that we like to use here to show about whether a mark is weak or strong or more distinctive or not. On the very, very cold side are generic or descriptive marks, and we're going to go through each of these. And then stronger marks are either suggestive, fanciful, or arbitrary. Let's talk about those generic marks. Very, very cold, very weak marks. Common everyday name for a good or a service, right? It is calling the thing what it is, calling the goods and services what they are. These are unregisterable. Think about the example of milk for a dairy-based beverage. That's what milk is. That's what it's called. So if there is a trademark that is registered for milk, one, it's not going to allow other people to be able to use the word milk for actual milk. And right, it doesn't indicate the source of who those goods are, right? Because that is what milk is, a dairy-based beverage. So these are very weak marks and they are unregisterable with the USPTO. Descriptive marks directly describe something about the goods and services. That could be the purpose and function of the goods and services, could be a characteristic, something about the quality of the goods and services, something in an ingredient in those goods and services. It is directly describing something about the goods and services. These are unregisterable on the principal register of the USPTO unless you can show that you have acquired so much distinctiveness in a descriptive mark that the public consumer would associate that descriptive mark as the source of your goods and services. There is a lot of evidence, a high standard of burden of proof that you have to show the USPTO that you have acquired distinctiveness in a descriptive mark. So more likely than not, this is going to be unregisterable on the principal register with the USPTO. The example here is creamy whip for whipped topping, okay? So whip is the actual whip topping. So right, that's generic for those goods. And then creamy is telling us something about the characteristic of those goods. So here, this is a descriptive mark. Suggestive marks, we're getting a little bit warmer on that temperature gauge graphic. These suggest a quality of the goods and services. They don't exactly describe what the goods and services are, something about the goods and services, but maybe suggest something. You need to take an extra mental step to think about these particular, how this wording connects with these particular goods or services. These are registrable. And think about copper tone for suntan lotion, right? So copper tone, the public consumer is probably not going to believe that they're going to turn copper by using this particular suntan lotion. It kind of suggests something about the quality of those goods, right? Maybe the way the skin is going to look once you use this particular suntan lotion, but you know, as a public consumer, you're not turning copper, right? Fanciful marks. These are some of the strongest types of marks and most distinctive types of marks. Invented words with no meaning in any language, something creative that you've made up. These are registrable. And think about Xerox for photocopiers. Even though it's probably well known, very distinctive, right? It's probably distinctive because it is a fanciful mark. It's an invented, made up word. Xerox for photocopiers, Kodak for cameras. Think about Kleenex for facial tissues, or Pepsi for carbonated beverages, right? Made up words. Yes, they are distinctive. We know them, but they are made up words. And then another type of really distinctive mark are actual arbitrary trademarks, which are actual words with no association with the goods and or services. These are registrable, and think about Apple for computers, Gap for those retail store services, or BlackBerry for smartphones, right? Okay, these are actual words, but in connection with the goods that they're providing or the services that they're providing, they don't have any meaning. Very, very distinctive marks. So let's do a knowledge check thinking about that temperature gauge. Our generic marks are very, very weak marks, not registrable. They just explain what a thing is. Our descriptive marks are just merely describing those goods and services. Then suggestive or just the quality, something suggesting something about the quality of the goods and services. And then fanciful or arbitrary are very strong marks that either is an actual word, has no connection to the goods and services, or something that you've just created, an invented word. So here, which is going to be registrable? Bicycle for bicycles or bicycle for playing cards? Looking over at the chat. All right, I'm seeing it coming in hot and heavy, right? Bicycle for playing cards. Bicycle for bicycles is generic. That is what we call a bicycle. So that's not going to indicate the source of those goods. But bicycle for playing cards is arbitrary, an actual word, but it has nothing to do with playing cards. That's an actual registered trademark. All right, so now we know what a trademark is, those trademark basics and fundamentals. We know what are the benefits of federal registration, what those rights you receive when you receive that federal registration, as well as how to select a mark, what you're going to be looking at when you're doing that homework prior to filing under that likelihood of confusion analysis and making sure that your mark is distinctive. Let's talk about that filing and registration process. This is a very linear graph of what it looks like when you file an application with the USPTO. You file that application, it's going to be reviewed by our trademark examining attorneys. It's going to, if we approve that application for registration, it's going to go through a period of publication to the public, letting them know, hey, this trademark is going to move forward to registration. If you have any opposition to it doing so, you need to let the USPTO know. If there's no opposition, or even if there is and it is not upheld, it's going to move forward to registration. Again, like I said, when you are filing and filing your fees in connection with your application, you're filing for review of that app or paying for review of that application and filing for those federal registration benefits. It is not guaranteed that your application may move forward to registration. How do you file that application? You're going to be doing that electronically. It's mandatory that you're filing that electronic application through our trademark electronic application system, or TEAS. You'll hear me refer to it as TEAS. There are two filing options in TEAS, and TEAS Plus is $250 per international class. TEAS Standard is $350 per international class. What is the differences in that $100 difference between those two filing options? Okay, with TEAS Plus, we are saying we want you to give us more information up front in your application, which makes it a little bit easier for the trademark examining attorney to review your application and for it to move forward toward registration. It's usually in reference to your identification of goods and services. So when you file your application, you need to let us know what your goods and services are that you're using your trademark with. And we have what is called our acceptable identification manual of goods and services. These are what has been already been accepted by the USPTO. We're saying if you go ahead and pull those goods and services out of that manual, that makes it a little easier for the trademark examining attorney to review because they've already been accepted by the USPTO. Now, say you have goods and/or services that are so new that they may not be in our trademark identification manual, that you actually need to write in your goods and/or services. If you have to do so, then we pass that $100 back to you, and you have to file that under a TEAS Standard application filing option for $350 per international class. Now, when I'm referring to international class, remember we don't have international or worldwide trademark rights. That just refers to the administrative headings for how we group or classify your goods and or services. Okay, so not in international, any type of international rights, just what World Intellectual Property offices have determined how to group the headings for particular goods and or services. We have 1 through 45 classes. That identification manual that the USPTO has thousands of entries of goods and or services. More likely than not, you will find your goods and or services in that identification manual. But just in case you don't, right, we're talking about intellectual property, innovation, and invention. It could possibly not be there. You would be filing under that T standard option. You're not going to be doing any math when you are filing your application. The total fee is going to be determined by how many classes that you have in your application, and that will be multiplied as you are putting them in the application in the system. So say you're filing under T's Plus for $250 per international class. You file that application with the USPTO for shirts that are in class 25. And then you're also filing for those handbags or tote bags in class 18. 2 classes at $250, $500 is going to be the cost of your application, and so forth. All right, what do you need in your application? You're going to have to let us know what your trademark is. We call that a drawing of your trademark. You're not actually drawing or sketching out what your trademark is. If it's just a word mark or phrase or a term or phrase, then you're actually just going to be typing that into the application. Or if you have that logo or some stylized font or color elements, design elements, you're going to provide us with a picture file of your trademark. You're going to list what your goods and services are that you're using in connection with that trademark. You need to provide us with a filing basis for each good and or service. That is the legal reason that you have to file your application. Really quickly, the most common filing bases are a Section 1A use in commerce filing basis. That means that you have a trademark, you're currently using it in commerce with your goods and or services, and you're able to show us evidence or a specimen of that trademark in connection with your goods and or services. Remember, you cannot receive federal registration until you are using that mark in commerce. So if you're already using it in commerce and you're able to show us that, you would file under that 1A filing basis, use in commerce. Another common filing basis is going to be the Section 1B or intent to use filing bases. That means you have a trademark, but you're not currently using it in commerce, but you plan to do so within 3 to 4 years. Say you just started your business, you're working on your products or your services, and you're not currently providing them in commerce yet. You can go ahead and file an application with the USPTO. That's going to prevent others from coming behind you that may have a confusingly similar mark for related goods and or services. And then at a later date, you would be paying an additional fee to file what is called a statement of use to let us know that, hey, I'm now using my mark in commerce. I'm able to show you that evidence or specimen of how I'm using that trademark in commerce in order to receive federal registration. You're going to provide us with your contact information and also the filing fees associated with your application. So we talked about the analysis that the trademark examining attorney is using when they're looking at your application. They're making sure you've met all those application requirements as well as statutory legal requirements. The most common types of refusals are that likelihood of confusion refusal and that merely descriptiveness refusal, right? One, that your mark is confusingly similar for related goods and or services with an already registered mark, or that it is merely descriptive, that it merely describes the goods and services, does not indicate the source of your goods and services. Other common refusals are that your mark is geographically descriptive of the origin of your goods and services. It just tells us where those goods and services are from, does not indicate the source of those goods and services. Or that your specimen does not support the listed items in your application. So remember, before you get registration, you have to show us how you're using your mark in commerce with your goods and services in the application. We call that a specimen. If your specimen does not match or support what you have in your application, you'll receive a refusal, and we're going to be requesting another specimen to show that. Or you could be using your mark in an ornamental manner. That's another common refusal. So think about goods such as like mugs, pens, t-shirts, baseball caps, right? And you have your trademark just emblazoned across the front of that baseball cap. We're going to say, hey, you're using that in a decorative manner. It doesn't really indicate the source of your good, of those particular goods. we want to see something like a hang tag or a label inside of that baseball cap, or your e-commerce site that has your trademark in where you can actually purchase that cap, and we can see it in connection with that trademark. So after you receive your federal registration, after it's reviewed by that trademark examining attorney, they push it through to publication. There's no issues as far as publication, and then it moves forward to registration. You have that U.S. registration. You are responsible for enforcing your own trademark rights. The USPTO cannot enforce your trademark rights. But once you have your U.S. registration, you can now send a cease and desist letter if you see someone using your trademark in connection with the same or related goods. You can send them a cease and desist letter. You could use your registration to sue an infringing user in federal court. And again, you do have to have that registration in order to do so. Now, you can have or be the owner of that particular trademark in perpetuity as long as you are filing your post-registration documents with the USPTO. You have to maintain your registration with the USPTO, continuously letting us know that I'm using this mark in commerce with the goods or services that are identified in my registration. That's over a period of time. And like I said, in perpetuity, and there are fees associated with those documents, but you have to be doing that in order to keep your registration alive in the USPTO database. All right, 2 quick knowledge checks before we get into some resources and materials. Are you guaranteed registration of your trademark? When you file an application with the USPTO, is it guaranteed that you're going to receive registration from the USPTO? Right? And I'm seeing those answers coming in quickly. Yes, no. Every application that's filed is going to be examined by a trademark examining attorney with the USPTO. They're making sure that you've met those application requirements and that there are not any legal or statutory legal issues, right? So there's no guarantee, right? You want to make sure that your trademark is registrable as well as legally protectable, okay? There's no guarantee. If your trademark registers, do you have to do anything to keep your registration alive? If it registers and you receive that U.S. registration, is that all you have to do, or is there something are there anything you need to do with the USPTO in order to maintain that registration? Right? I'm seeing those answers coming in very quickly. Yes, the answer here is yes. You must continue to use your trademark. You have to be using it in commerce with the goods and services identified in your registration, and then you're going to be filing what are called post-registration documents with the USPTO. All right, so we've gone through everything regarding the federal registration process, what a trademark is, and how to file with the USPTO. Let's go through some resources that the USPTO has to help you with that process. First, I just want to bring up really quickly our caution about scams. Being aware of scams, being aware of filing firms, and being aware of misleading notices and offers. When you file an application with the USPTO, it is public record, okay? It has to be. We're talking about innovation and intellectual property. So those who already have registered trademarks need to see what's coming down the pipe as far as trademark registrations, right? So to prevent any type of likelihood of confusion, so it needs to be made public. Your information as far as the email address that you use for correspondence with the USPTO is also public record. So you may receive solicitations from possibly attorneys that want to seek your business with assisting with your trademark application, but you'll also receive scams, people sending you correspondence, emails. If you submit your telephone number, your application, they may be calling you saying, hey, we can guarantee you registration of your trademark if you send us money, if you provide us with your credit card information, so forth, things of that nature. One, we just talked about there's no guarantee that your application will move forward to registration. So you already know that is not true if someone were to send that to you. And secondly, the USPTO or any employee of the USPTO is not calling you and requesting any monies from you directly. We're not going to be asked, your trademark examining attorney is not going to be asking for your credit card information for you to send them any money directly. Anytime you pay a fee to the USPTO, it's going to be through our electronic application system. It's it's not directly to any employee, they would not be requesting that type of information from you. So that just provides a link of what to look out for once you file your application, what may be being sent your way. Also being aware of filing firms. These are firms that say they can just file the application on your behalf. Look at what type of services that they provide. Really, only you or your representative, like an attorney, should be filing an application on your behalf. A filing firm would not be able to respond to any correspondence that you receive from the USPTO. Only you as the applicant or your attorney can do so. Your hub for all things trademarks is going to be uspto.gov. We also have this website that's going to show you trademark videos from a attorney member of my office in trademark customer outreach about all different types of subject matter related to the federal registration process. So smaller chunks related to the federal registration process, whether that's, hey, I just want to know how to file the application, what the system looks like, what it's going to look like when I actually file. We have a video for that. Hey, I want to learn how to actually do that homework. I want to learn how to do that comprehensive search before filing my application. We have videos for that. So that is where you can find our videos. This QR code and the link here goes to our Trademark Basics Registration Toolkit that provides more concise information and handouts related to the federal registration process. I'm showing a link here in a screenshot of our Trademark Basics Bootcamp. This is a free 8-week series that the USPTO provides about the federal registration process, from trademark fundamentals all the way to what happens after you receive your federal registration, how to file those post-registration documents. Over an 8-week period, one webinar a week at an hour. You can look at the agenda here at the link. The next one will be starting in January. You can attend all 8 sessions, or you can just attend the session that is relevant to where you are in your federal registration process journey. Okay, I'm currently teaching the last session of this year. We have our last module next week, Tuesday. And it is all about Q&A, about any questions that you have about the federal registration process. And then the next boot camp will start again in January. And you can find the link there to sign up. Again, this is free. We have our IP identifier. This is a QR code and the link to that. Say you have a trademark, but you might also have other different types of intellectual property. And you're thinking, I don't know what type of intellectual property I have. This is a quiz that allows you to provide information and then will let you know, hey, you may have this type of intellectual property and where you need to go to get federal protections. There are 4 types of intellectual property really quickly. We talked about trademarks today, which indicate the source of goods and/or services. You have patents, which protect inventions. You come to the USPTO for protection for that as well. You have copyrights, which protect artistic or literary creations, original artistic or literary creations in fixed form. You receive protection there at the U.S. Copyright Office, copyright.gov. And then there are trade secrets. These protect valuable information that are only protected by taking steps in order to keep that information a secret. Think about the Coca-Cola recipe or the KFC recipe or the WD-40 formula. Those are trade secrets. Free services and resources that the USPTO provides, you can find at the link here. It's going to include both patent and trademark information and programs that the USPTO provides. And then on our website, we have our USPTO virtual assistant. This is where you can ask 25 of the most commonly asked trademark questions, and an answer will come out for you there with the virtual assistant. This is a great resource, our Trademark Assistance Center. This is going to be the main support center for all trademark customers. At the telephone number, they are available Monday through Friday, 8:30 a.m. to 8 p.m. Eastern Time. And if you send them an email, they will respond within 24 to 48 hours. This is, like I said, a very great resource. Say if you are receiving those fraudulent communications or notices and you're like, I don't know what is going on, what this document says. Do I have to pay money? Is something going on with my application? What if your trademark examining attorney contacts you out of the blue? Christina Calloway called me and said she wanted to talk to me about my application. I do not know who this person is. You can contact the Trademark Assistance Center. They can let you know whether Christina Calloway is an employee and if she is your trademark attorney. examining attorney for your application. They can let you know if the correspondence you have received is from the USPTO or whether it is not from the USPTO. Just a few quick reminders. The USPTO does not provide legal advice. Yes, your trademark examining attorney is a licensed attorney that is reviewing your application, but they cannot provide you with legal advice. They wouldn't be able to tell you, hey, your trademark is valid, or I think this about your trademark, or you need to change these. They're not telling you any type of legal advice. They're only assisting you with the application and getting it to registration. We do not enforce legal rights after you receive that U.S. registration, and we cannot and do not recommend specific private attorneys. Okay, if you're looking for an attorney, you would have to do that through your own research. All right, we're now at the questions portion. If you have any questions, I know Robert was looking in the Q&A during the presentation, and if you have any, now you feel free to drop them in as we go along. I am going to stop sharing. And if I need to pop something back up, just let me know, Robert. All right.
Excellent. Thank you, Christina. Great presentation. So we had a question just pop up and you had just touched on it, but you might be able to expand a little more. It says, where can we find a good resource for trademark attorneys here in the Phoenix area?
Okay. So from the USPTO side, since we can't recommend specific private attorneys, we say that you can look at the American Bar Association. That is going to have member attorneys there. You should be able to do like a drop down for intellectual property or trademark attorneys, and you can see where they're listed. And then for your state, every licensed attorney has to be barred or registered, barred or licensed in the state. So you can go to the Arizona, it may be called State Bar of Arizona or Arizona State Bar, and you will be able to find attorneys. They'll have listed their names as well as like what firm or if they have their own offices. And you can also search by the practice area, trademarks or intellectual property that they are practicing. Now, the USPTO does have what we call our law school certification program. These are law schools all over the country that have IP or intellectual property clinics. These are law students working under a licensed attorney who is their professor that can assist you with applications at either a free or reduced cost legal services. So you can go to our website, just go to the search page. It should be the search bars in the top right-hand side. Type in law school certification program. It will pop up the schools that participate in that program. There are schools in Arizona, law schools in Arizona, as well as there are some in other states that provide assistance to clients all over the country. Trademark law is federal law, so you can have an attorney that represents you from another state. And if Robert, if you have any resources that you provide as far as attorney assistance or finding an attorney.
We recommend the same thing when you're looking for an attorney, the same spots. So the next question we have is, and this goes back to something earlier, but I think more detail maybe helps us. Do I need to use specific font and size to use the TM or SM?
No, so you can, however you showcase your particular mark, your brand name, your logo, your slogans, you can just put TM. Usually you see TM and superscript above somebody or next to somebody's mark, but as long as it's there, it doesn't matter where it is. So usually people just put it in standard typeface front next to it, next to whatever their mark is. You'll see sometimes a little TM there, or SM if it's for services.
Yeah, I found it interesting the first time I went through this that depending on the fonts you use, if you use a non-standard font, then it only trademarks that one font, correct? On your logo or branding.
So referencing like font or stylized font and specific to your trademark. So for TM or SM, you can just use a standard font that just shows that this is a trademark that you have. It's not a part of the mark that you have. Now, when you're filing an application, you're letting us know what your trademark is and then how you're using that mark out in the marketplace. So there are two types of formats. So you could have a standard character format where that is just, I want protection for the wording in my mark. Regardless of how I style it, how the font that I'm using or the color, you can display it in any way in the marketplace. You just have protection for the wording or the wording. So you just be typing in that particular wording or phrase, like I showed Coca-Cola with typeface font. They have
Mhm.
protection for just the wording, but we normally see it right in that formal script that we usually see written on their bottles or on their labels. Then you can have what is called a special form trademark. That's more of what we think about with logos. So either some stylized font, or you have design, just the design or wording and design together in that trademark. That's a special form format, or color associated with your mark. So you make a determination as the business owner of what you want to protect. We sometimes recommend, hey, get that standard character format, because that means at least you just have the terms protected and you can display it how you want to out in the marketplace. And then you can also file additional applications for how you're using it in special form, right? So think about Amazon. They have Amazon just for the wording. They have Amazon with the smiley face symbol. They have the smiley face symbol alone as a registered mark. So you as a business owner are making that determination of what's important to you to protect as far as your trademark goes.
Great. You just answered my next questions I had. So you got it all in one shot.
Yeah.
Um, so that's all I have. I mean, it
Okay.
covers a lot. We have another thing pop up in Q&A. I don't know if that was it. I forgot to clear it.
Same attorney. Okay.
So I think we are good. We don't have any more questions.
All right.
Just a reminder, everybody, we did record this, so it'll be available in our content library if you want to go back and watch it. We also have the slide deck we'll be able to share as well with everybody. So, Christina, thank you for joining us.
Thank
We
you.
appreciate you taking the time and dealing with the few hour time difference to be with us. But it's always great to have the expert with us to share it the way you guys are seeing it there in DC. So, we don't have any other questions. So, thank you very much, Christina, and I'm sure we'll talk soon. But everybody, thank you for joining us for this Lunch and Learn. We hope you enjoyed it. If you have any questions later that pop up, feel free to email me and I can contact Christina or get to the two of you in contact. But again, thanks for being with us, and we hope to see you on next Tuesday's boot camp webinar. Until then, have a great rest of the week and great weekend.